Good morning, participants. It's lovely to have you here this morning and welcome to our March webinar. I've waited until now just to let the last people in, but I think we are ready to start. I'm going to share my screen just to introduce our speaker for this morning. It's my colleague, Robyn Siebers. She's a seasoned and known litigant, but she's also very active in family law matters and family law assistance where people go through difficult times. She deals a lot with maintenance in the maintenance courts, and she's an ideal person to address you on maintenance matters this morning. Before we go to the practicalities and before she starts speaking, I just want to mention one or two house rules. Please mute yourselves during the meeting, otherwise the noises make that you cannot, people can't hear well enough. The presentation slides we won't be making available as that is part of our intellectual property, but please visit our brochures that you will find on our website. There's loads of handouts and those you are welcome to use and get further information from. Robyn won't be answering questions after this seminar simply because we have in family law matters often that both spouses attend the same talk, and you can therefore not make comments that might impact a matter that they have between them. So because of the personal aspect of maintenance claims, she will not answer during the presentation, but please, if there are any questions, post it in the Q&A that's at the right side of your screen. She will collect those and put it into a note, answer the questions, and that will be shared with you in the course of next week. So your questions will be answered in that way. And remember, for any administrative queries, you're welcome to contact our marketing department. The email is marketing1@stbb.co.za. And otherwise, for anything to do with maintenance matters, please feel free to contact Robyn that you see on the screen just now. Her email address is robyns@stbb.co.za. You would have seen that the previous slide that I skipped over, the disclaimer, I didn't skip it over because it's not pertinent. It's a general disclaimer just to say that information we give here is to the best of our knowledge true and correct, and I can guarantee that I know whatever Robyn says and her experience is adequate and correct, and she knows maintenance matters very, very well. But the point is, this is a general talk. There's very many legal rules that she might touch on, but legal rules are always adapted according to the nuances of a specific matter, and hence the disclaimer: you cannot just take a rule and paste it onto a set of facts. Each set of facts differs, so the rule will have different interpretations depending on that. So without more, I'm handing over to Robyn, and I hope you enjoy the session.
Excellent. Thank you, Marina, and thank you to everyone who's joined us today. I will be putting up a presentation, so you don't have to look at me the entire presentation. So let me get that on the screen. Morning, thank you. There we go. So as Marina touched on, STBB's family law team has extensive experience in all areas of matrimonial law and also maintenance matters. So we thought it would be helpful to give an overview of our maintenance courts and the processes so that you can understand what to expect if you need to bring a maintenance claim or need to deal with a maintenance matter. So during the next hour, I'll be giving you an overview of the maintenance courts, where you can find them, and then I'm also going to talk you through a practical step-by-step explanation on how to go about applying for a maintenance order. So that's relevant to those of you who don't currently have a maintenance order in place and you need to obtain one. And then I will also speak about how to go about varying an existing maintenance order. And lastly, I will close off with discussing the options of enforcing a maintenance order in the case of a breach. So maintenance courts, where will you find them? Every magistrate's court within its area of jurisdiction also has a maintenance court for the purposes of the Maintenance Act. So if you are needing to bring an application, you can bring it in the maintenance court in the area where you reside, and you can also bring it where the respondent resides or is employed. So why do maintenance courts exist? Of course, we have our civil courts and our criminal courts, but there's a maintenance court at every magistrate's court, which is specifically created for the purpose of dealing with maintenance-related matters. So the Maintenance Act creates a good legal framework for enforcing rights to be maintained, but the intention of creating an actual maintenance court is to provide a system that ensures that the framework can operate effectively. What you might encounter in practice is that some of the courts can be a bit frustrating. I think they are still trying to iron out the processes and trying to get things streamlined. But the intention is at the end of the day to protect one's right to be maintained. And that is why there's a focus on or a specific court just to deal with maintenance issues at every magistrate. So I've said maintenance order this, maintenance order that. Of course, if you don't know what a maintenance order is, it's a court order which regulates the legal duty of a person to maintain another. That's irrespective of the nature of the relationship between those persons, giving rise to the obligation. Examples of maintenance orders can be for spousal maintenance or child maintenance. Most of my talk today will be focused on child maintenance. Spousal maintenance is more often than not dealt with within a divorce. However, you can still approach maintenance courts to deal with spousal maintenance and to vary orders regarding spousal maintenance. So what do we look at when dealing with maintenance orders? So the duty to support a child depends on what is required for his or her proper living and upbringing. This includes the provision of clothing, food, accommodation, medical care, and education. You'll see the word in the first sentence which says what a child reasonably requires. If you look at the word reasonable, this depends on the circumstances of each case, and the court will look at the parent's means, the child's normal standard of living, the social position, the child's health, and when it comes to education and tuition, they'll look at, well, naturally every child has the right to education, but more so when dealing with tuition fees, the court will consider the child's aptitude and record. So determining the amount to be paid, the court considers that the duty of support is a joint obligation between both parents. It doesn't only fall on the shoulders of one parent. The court will look at the parents' respective shares of the obligation, and that obligation has to be apportioned between the parents in accordance with their means. What that sort of looks like is the court will do a calculation to establish what the child's reasonable expenses are, and those expenses then have to be shared between the two parents. It's sort of an equation. I'll touch on it later when we look at the form. but it's in accordance with their means. So if one parent earns double what the other parent does, he will pay a far larger portion than the parent who earns less. But that doesn't mean that the parent that earns less doesn't have to contribute. The duty also exists where the child's born in or out of wedlock. I'm sure most of you know that, but just because two people are not married doesn't mean that they're not obligated to maintain their child. It's also irrelevant whether a child is born out of a first or subsequent marriage. The child's right is still equal to the sibling. So now that I've explained sort of the process and, or rather the courts and the requirements, let's look at the different steps. So from the moment that you approach the court to apply for a maintenance order, what that process sort of looks like. Remember, each maintenance court process may differentiate slightly. So it is the process as defined by the Act. But some courts make their processes more simplified, some may take longer at certain stages. After this, I'll also show you what the form looks like so that you can have an idea of what to expect on that. So in order to get a maintenance order, naturally you would have to bring an application. You can apply, like I mentioned earlier, at the court where the child is resident, but you can also apply where the respondent resides or works. So step one is complete an application form. This form is known as Form A. You can download it online. We will share the link with you, but it's, if you Google maintenance application form, you will get it. And you will have to, you can also get a copy at court if you want. So you'll complete the maintenance form by setting out your monthly expenses. There's a detailed schedule that you have to fill out. And once you have completed the form, you will have to put it with certain supporting documents, such as 3-month salary slips, 3 months bank statements, proof of all the expenses that you've listed, a copy of your ID, a certified copy of the child's birth certificate, proof of residence, and full names of the respondent and the respondent's address or place of employment. So if you don't know where the respondent lives or works, you might have to appoint a tracer. Hopefully you know their name. Step 2 will be to naturally submit the application form with your supporting documents to the clerk of the maintenance court. Once the application is submitted, there's a duty on the court to establish the financial position of both parties. So they have to look at assets and liabilities, and the maintenance officer and maintenance investigator will have to conduct an investigation. But before they do that, step 3 is that you've submitted your application. You won't hear from them for a short while, and then you should be sent a directive to attend court. That same directive will be served on the respondent. The directive is a subpoena, as some of you may know it, which tells you about the court date and says you have to attend a certain day and bring certain documents with you. Both parties must attend. And then on the first return date, there's what we call step 4, which is an informal inquiry. Once you arrive at court, you generally fill your name on a waiting list. And then when the maintenance officer is ready, he or she will call you into his or her office. And the maintenance officer will have a discussion with both of you. The applicant will have a chance to tell the court why they are there, and the respondent will have a chance to respond. He or she, as in the maintenance officer, will consider any documents which are being presented. And at that stage, the maintenance officer might suggest or encourage the parties to take a few moments and see if there's any chance for reaching a settlement. I mean, settlement in most cases is the best outcome for all. It avoids you having to go through the lengthy process of the formal inquiry. So the maintenance officer may encourage you quite strongly to see if there's a middle ground. If you do reach an agreement at that stage, the settlement agreement can be made an order of court there and then, and that's the end of the process. Then you have your order, and you don't really have to return to court unless there's a problem. If, on the other hand, the parties are not able to reach an agreement at that stage, the matter is referred to a formal inquiry. It won't be referred, or it won't proceed to a formal inquiry immediately. It will, in all likelihood, be postponed for the formal inquiry. And because in the interim, there's most likely further investigation that has to take place. So the maintenance officer will tell the magistrate that the parties have been unable to reach an agreement, and she'll then set a new date for the parties to return to court. At that stage, they might also make further directives for either party to discover certain documents by a certain date, and sort of explain the process of what needs to take place between the informal inquiry and the formal inquiry. Preparing for the formal inquiry is where the maintenance officer will have to start preparing the paperwork for the formal inquiry. As I said, they may need further discovery from either party. They may also subpoena documents from a financial institution. So if the respondent or applicant don't want to provide certain bank statements that you know for a fact they have, or you know they're employed and they don't want to give their pay slips, the maintenance officer or maintenance investigator can issue subpoenas to get those documents from their institution. Then you will return to court. So there may be a few postponements in between the informal inquiry and the formal inquiry. The purpose of that is generally just to get more evidence. The court has to be satisfied that there's enough evidence before the court at the formal inquiry to enable them to make a decision. So then at the formal inquiry, it's somewhat a mini trial or a hearing, and it takes place before a magistrate. Unlike ordinary civil procedure, the magistrate plays quite an active role in ensuring that sufficient evidence is obtained. So even if there are legal representatives, the magistrate will ask questions and can request that further evidence be obtained. And if such evidence isn't presented, then the magistrate will draw an inference from that. So it's not necessary to have legal representation in maintenance court, but it can be quite intimidating. So you are allowed to have legal representation. It's important that both parties are present for the formal inquiry. Both parties will have their own supporting documents that would have been handed into court and may be required, or most likely will be required, to give evidence under oath, oral evidence, and will have to assist the court in establishing their respective means and the reasonable expenses of the children. In the last step, after the magistrate has heard the necessary evidence and is able to draw a conclusion, the magistrate will make an order or not make an order if there's not sufficient reason. When we come to varying maintenance orders, those applications could be dismissed if the magistrate's of the view that there's not sufficient evidence. So just to summarize some of the role plays that you will encounter when you are applying for a maintenance order, it's the clerk of the court, a maintenance officer. There's a maintenance investigator as well who assists the maintenance officer with the investigation, and then there's the magistrate. So this is what the form looks like. You'll see on the top left, it says application for a maintenance order. I'm not going to go through all the details with you, but in essence, you put the applicant's details, the respondent's details. Oh, so where I say applicant, it's also called a complainant. And when I refer to respondent, it's also called the defendant. So when you're looking at the form and you see those two terms, you will know why it varies, but both are appropriate. And then on the page on the right, you'll see that it says at point 4 that you set out exactly how much you want the respondent to pay. And then in that, in those blocks over there, you'll see how much you have to set out how much you want to be paid in respect of each child. This is the schedule I was speaking about earlier. It looks a little overwhelming, but it's not too complicated. This is for the applicant to complete. Applicant has to set out assets, income, and then the expense schedule, which is very important because the expense schedule helps the court to understand, for example, at point 1, lodging, if there's a bond repayment, if there's rental to be paid, you would put the total amount of the rental in the total column. And then, so the calculation to work out how much a child's portion is 1/3. So the adult's portion, so if it's an adult and one child, the equation is 1/3. And if there are 2 children, then it's 2/4. So for example, if your rental is 9,000 Rand a month in total, let me just check my math, then 2/3 of that is allocated to the adult, so 6,000, and 1/3 of that is allocated to the child. If there are, like I said, 2 children, the equation is 2/4. So half would be allocated to the adult and the other half to the 2 children. So you have to do that for every single expense. And you'll see the schedule is quite detailed. It goes to things like Wi-Fi, TV license, gifts, car, petrol, transport. So it's very comprehensive. It makes provision for all expenses. That is because naturally having children in your home, they are using the electricity, they are using the water, they are in the property, so they are the respondent needs to contribute towards those expenses. I don't have the last page of the application form, but below point 19, there's a totaling box where you put the total, so it adds up basically the total expenses and then the child's expenses and the adult's expenses. So that total is what the court will use to see, okay, these are what the child's expenses are. And earlier I mentioned that the child's expenses have to be apportioned between the 2 parents, pro rata in accordance with their needs. So once you have the child's total expense, that amount still has to be divided further between the 2 parents. So if they earn similar salaries, they'll each be liable for 50% of that amount. Yeah, so it's a little bit complex to explain, but there is a form available online which explains what to complete where. I can make that link available also, as it helps a bit with the details of the form. Okay, so now that we have explained how to go about applying for an order, I think, and this is actually quite a complex part of maintenance orders, which is how you go about varying an existing maintenance order. I say complex because, as Marina mentioned at the beginning of the session, is that yes, there are certain rules and laws, but magistrates, of course, they're bound by the law, but a lot of this comes down to the circumstances of each case. So there is some room for interpretation, and it's not always, I often have applicants coming and applying for a variation of an order, and they think that it's going to be quite easy. It's not always. The onus, especially when it comes to applying for a reduction, the onus is quite, the threshold is quite high to prove that a variation is warranted. So if you have an existing maintenance order, it can be a divorce order or an order granted by the maintenance court. You can apply to the maintenance court to have it varied. As I said, that's even if it's a high court order, the maintenance court will have jurisdiction. Maintenance due in terms of a court order remains due and payable unless ordered otherwise by a court. We often get a question, if the order in respect of maintenance for a child is silent on when the duty to support terminates, does it just continue indefinitely? Well, there is a duty on parents to maintain a child until the child is self-supporting. But if the order doesn't specify that it's valid until the child becomes self-supporting, then it ceases at the age of majority, or if the child becomes self-supporting before reaching majority. I do find most consent papers or high court orders rather generally do say that the maintenance arrangement shall continue until the child becomes a major or becomes self-supporting, whichever happens last. And that is quite a contentious point because it can be tricky to establish exactly when a major has become self-supporting. So if you are no longer able to afford the maintenance that you've been ordered to pay, you can approach the maintenance court to apply for a downward variation or a discharge of the maintenance order. Then on the other hand, if you are the recipient of maintenance and you find that the contribution that's being made is simply not sufficient anymore, you are entitled to apply for an increase in maintenance. Again, I'll show you this form after this segment. It's quite similar to the form for an application, but yes. Then same process. If you want to vary an order, you'll have to complete the form and approach the maintenance court to request a variation. Interesting topic is that the maintenance officer has to be satisfied that there is good cause shown to consider the application. If an applicant is unable to establish good cause, there's a possibility that the court will not consider further evidence on the matter. Some magistrates might say, well, the parties are before me, let's run the formal inquiry, and then at the end of it, we can establish whether there's good cause. Other courts may sort of hear you on the first day briefly only on the subject of good cause, and then dismiss the application before actually going into the details of the evidence. And again, as mentioned, when establishing good cause, the court has to consider the particular circumstances of each case. So there's not just a blanket rule that, like a mathematical equation that you can just say, yes, there's good cause or no. So the same inquiry process that I explained earlier is followed by the court, and the court in this process will have to conduct a financial investigation into the party's means, ability to pay, and they usually look for a significant change in circumstance warranting the variation. That's especially when you maybe got divorced in the High Court or the Regional Court and you signed a settlement agreement. If you entered into a settlement agreement 1 or 2 years ago, and in terms of that settlement agreement, you've undertaken to make certain contributions. If you now approach the maintenance court a year or two later and say, well, I can't afford these contributions anymore, your financials are going to be scrutinized quite in detail, because you're going to have to show that what I agreed to a year or two ago is just no longer affordable, and the court's going to want to see evidence on that. So you'll often hear the term change in circumstance. This is one of the hurdles you'll have to get over to show the court that that there's been a change. More commonly, I suppose it would be you were employed at that stage earning X. It's now 2 years later, you've lost your job, or your income has been cut in half and you simply cannot continue to afford what you were paying. So you'd have to show the court proof of that. And in order to make a decision, the court would have to consider the party's means, earning capacity, financial needs, and weigh up, if it's spousal maintenance, I suppose the applicants need to be supported against the ability of the respondent to pay. So as I said, you have to give documentary proof, and you have to show that there's been something that's occurred after the previous order was granted, which has significantly impacted the circumstances. If you're applying for a decrease in maintenance, the court is also inclined to actually look at your assets. So you cannot say, oh, I'm now earning half of what I was 2 or 3 years ago, but you've accumulated all these assets. The court at that stage can say they're not going to order a reduction. You have to sell the assets to continue carrying out your obligation. As I said, the court considers parties' means, earning capacity, financial needs and obligations, and the court has to weigh up the child's right to be maintained and the respondent's ability to pay. Also, a respondent isn't supposed to just be able to sit back and say, well, I've become unemployed, we need to vary this order. What the court can do is say, you need to show what you've done to try and apply for a job, and then maybe postpone the matter so that the respondent has to come back to court and say, these are all the interviews I've been for and I haven't been successful. So the court has a responsibility. They have to rely on the Constitution, case law, and the Maintenance Act. And the determining factor in, suppose, their decision will be what's in the child's best interest. The court cannot order someone to pay more than they can afford. But at the same time, when considering whether to order a reduction, it has to be a last resort. So like I said, they're going to look at assets, they're going to look at what other options there are before ordering a reduction. So this is the form. There's definitely a page, I think, that I've left out. So you'll see at the top it says substitution or discharge of existing maintenance order. As I said, this same form is used whether you are the person paying maintenance or you are the recipient of maintenance. You'll set out your details over there. And then on the right, there's a block which says how much is being paid. So this form is different to the form for the application because it has two sections where you set out what is currently being paid, and then you'll see up here it says, I can't say it's blocked, but substitution of the maintenance order, and then here is where the person who wants the order to be changed will set out what they would like it to be, when they want the first payment to be, and any other additional information. If the person wants the order to be discharged, you'll see at the bottom below, or they can fill out the details there. So the process is the same as I mentioned. There'll be a informal inquiry once the form has been submitted. There'll be an informal inquiry, and then if the parties can't agree at that stage to a reduction or increase, then it will be referred to formal inquiry. So that was how to apply for a maintenance order, how to vary your maintenance order, and then last but not least is enforcement in the case of non-compliance. So when a person against whom a maintenance order has been made fails to make payment in accordance with that order for 10 days or more, the order is enforceable in respect of any amount which that person has failed to pay, together with interest. So, for example, if your maintenance order says the respondent is liable to pay 5,000 Rand a month and 50% of medical expenses incurred by the applicant, if either of those or both of those have not been paid, you are entitled to approach the maintenance court and say, here's my order, it has not been complied with, and you can ask them to do one of the following things. You have to approach the maintenance court where the order was made. I think you can also approach where the respondent is living or working, but I stand to be corrected on that point. So you can ask the court to issue a warrant of execution, to make an order for the attachment of emoluments or the attachment of a debt. So when making an application for the enforcement, you have to show the court that the person liable to pay has defaulted on those payments. Now, the best way to be successful in an application like this is to set out very clearly and concisely what payments were due to you and what payments were actually made, so that you can show the court the shortfall. Together with your application form, you will also need to provide bank statements for the period. So if you are bringing an application for a warrant for maintenance that hasn't been paid for 5 years, you're going to have to present the court with bank statements for that period so that they can see that you have actually not received the money. And then you also need to present the court with evidence of receipts and proof of payments for any amounts that you have paid and the respondent is supposed to reimburse you for. So we usually use a schedule which sets out those amounts clearly, has the totals, and then it's easy for the court to establish what the amount is, and also look at the evidence showing that those payments haven't been made. If the court does order a warrant of execution, the warrant will be issued by the maintenance court, and the warrant plus a copy of the application will be handed to the sheriff or the maintenance investigator for execution. Now, the nice part about maintenance courts as well is that the warrant of execution will be executed against movable property, and if there's insufficient movable property, it can also issue a warrant against immovable property. So that's a process that can also be done by the High Court, but if you can't afford legal fees, at least the maintenance court is accessible for that purpose. So the person against whom a warrant of execution has been issued does have a right to apply to maintenance court to have it set aside, but they have to show that they genuinely couldn't afford the payments. So it's quite difficult unless they've really been without means. And then emoluments, this is also known as a garnishee order. This is where the court makes an order for a employer to pay over the amounts to the applicant. So that order will be served on the respondent's employer, and they have to make the payment to the applicant. Then attachment of the debt. This order will be directed at someone who's obligated to pay a debt to the respondent, and the order will inform that person of when and how they need to make payment to the applicant. There's also another process which I won't go into too much detail on, but failure to pay maintenance is also a criminal offence. So in terms of Section 31 of the Maintenance Act, you can lay a criminal complaint for failure to pay maintenance. This, however, won't be prosecuted in the maintenance court. It will be referred to the criminal court. And in that case, it becomes the state versus the respondent. As a defense, so the respondent may be able to prove that he has had she has had lack of means to pay, and they might get away with it. So I think that is predominantly everything that I wanted to share with you today. Oh yes, I did say that you can apply to suspend the warrant of execution, and the same goes for whether it's a garnishee order. The respondent can apply to court to have it set aside, but again, they have to show that they genuinely were not able to pay it. And in that case, the court is also going to say to them, well, why didn't you approach the court for a reduction if you couldn't afford it? Here's the form, which it's only 2 pages, but it's not as easy as you may think, because you have to have all the supporting documents. It's not easy, but it's not going to be just 2 pages, because you're going to have all your bank statements, all the schedule that you've drafted, and supporting documents with this application for the enforcement. And where I spoke about a warrant or attachment of emoluments or attachment of debt, you'll see under point 1, they have A, B, and C, which sets out where you can select which option is going to be best. So that brings our discussion to an end. I thank you all for joining, and I hope that you learn something or feel a bit more confident if you need to take on a matter at the maintenance courts. And if you would like more guidance and assistance, you're welcome to reach out to us, one of our team members. Thank you, Morena. Over to you.
Thank you, Robyn. This was absolutely a stunning presentation, and listening to it, I learned a lot, many things that I never knew. Especially the mention of, irrespective of the nature of the relationship, that there's different instances where maintenance is payable, and what to do if you went at it yourself and you forgot to insert certain things in the order, what to do if your order is silent on certain matters that you realize is relevant, and also the details of varying the maintenance order, what to do to show to a court what is good cause. Because if you on the receiving end, you might think it's reasonable and it's warranted that the order may be varied, but what a court will consider good cause might be quite a different thing. So thank you for highlighting the details. And I must say, from a personal point of view, I think it is most valuable to work with a professional like yourselves if you are attending to maintenance or varying of maintenance orders. So thank you, Robyn, and thank you everyone for attending. I hope you have a wonderful Easter weekend ahead. And as Robyn said, contact her at any time should you need assistance. You will find her details on our website, or otherwise she's at robyns@stbb.co.za. Thank you so much.
Bye. Thank you.
Hi.